Any mention?
May please Lordship. This item number 18, my lord.
Yes.
This is, I beg to mention it may come after 2 weeks, my lord, because there's some kind of compromise outside the court. The party is going on. I have the application there in the, before this one. I have not able to.
There will be a settlement.
Yes. Yes.
No objection, Lordship.
Has it been recorded that there is an effort to make a
That letter I have actually, but then I unfortunately could not bring. But it is I have received a letter which they have submitted to
we'll
the
just simply
CEA.
adjourn it on your prayer.
Yes, sir.
On prayer made by Mr. Petition, London Council of the Petitioner. This is matter after 2 weeks.
Lordship.
Yes.
The Lordship, the similar prayer, this item number 24. This is regarding POXO that which is pending in the division bench. I think it will come in the month of somewhere in the
Just make it 4 weeks. Item 20?
24, my lord.
Yes.
Lordship.
May I please,
Much
Lordship?
less, Lordship.
May I please, Lordship? I beg to mention item number 25.
Yes.
25, 26, Lordship. Connect.
Yes.
I pray for 1 week time, Lordship.
You are appearing for?
Respondent number 2.
And who is for the petitioner?
I already informed them.
No objection, Lordship.
Okay, on prayer made on behalf of the respondent number 2. In both the cases, you are respondent number 2, 25, 26.
Yes, Lordship.
This is matter after 2 weeks. Yes.
Much obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to make a mention for item number 12, Your Lordship. The conducting counsel, Your Lordship, is not available because he had to go for his checkup on health grounds. Item number 12. We are the petitioners, Your Lordship, in this
There is
case.
a part-heard matter. Mr. Nath, there is one difficulty. The court has gone through these things. One officer, Mr. G.S. Das, is involved there. Is he Gauri Shankar Das? The former.
I have to clarify.
Kindly see if he is the man involved, because against him is allegation, then this bench will not take up the matter. There will be some technical difficulty. You see the representation of the petitioner, which was addressed to the department in this case. You will find some accusation has been made against one senior officer,
Yes.
whose name is G.S. Das.
Yes, that's.
Yes. If he is Gauri Shankar Das, then this court will have some difficulty in taking up the matter. He was probably, I think, senior manager or something here, there.
Yes.
Now must be retired man.
Retired.
Anyway, just verify. Just
I'll verify it.
yes,
2 weeks, Your Lordship.
Huh?
2 weeks.
2 weeks.
Yes, Your Lordship.
Then what?
Your Lordship, actually, my senior, his health is down, Your Lordship, on health grounds.
No objections. Yes. On prayer made on behalf of Mr. S. P. Mahathir, London Senior Counsel, appealing for the petitioner. Not objected. London Counsel, comma, just who is stated to be in disuse. Comma, this is matter after 2 weeks. Yes.
Your Lord, similar prayer for item number 21, Your Lordship.
21.
21, Your Lordship. Petitioners, for sure.
21 you are appearing for?
I'm for the
You are there.
I'm for the petitioner.
This
I'm
on
for
prayer-
respondent number 3, Your Lordship.
Yes, on prayer made on behalf of the London Senior Counsel, appealing for the respondent number 7, sir. This is matter after 2 weeks. Yes.
Obliged, Your Lordship.
Please, Lordship.
Yes.
Mention item number 22, Lordship.
Yes.
Pray for 2 weeks' time, Lordship, for hearing.
No objection.
22 on prayer made on behalf of the respondent. This after 2 weeks. Yes.
Obliged.
May it please Lordship. Lordship, I
Yes.
beg to mention item number 15. Lordship, I'm praying for some accommodation for today.
You are appearing for?
I'm praying for the petitioner in this matter.
I'm paying for the statement.
Yes.
2 weeks.
No objection.
This also speaks on the prayer made on behalf of the petitioner. Yes.
Highly obliged.
Please, Your Lordship. I beg to mention item 9, Your Lordship. The matter is similar matters pending before Honorable Supreme Court, Your Lordship.
Item 1.
9.
Item 9. Yes, this matter is?
Your Lordship, the matter is about equal pay.
This is a 2013 matter.
Yes, Your Lordship. Similar matters pending before Honorable Supreme Court. That's why, Your Lordship.
Check the last order. When that matter before Apex Court is coming up?
Your Lordship, it has not been listed since April, Your Lordship.
There are 2 matters connected. Both the matters are same.
It's just 9.
So 9 is with
9 with P and Ganesh. Yes, Your Lordship. Both.
Okay. Just see the last order and just list after 4 weeks.
Sorry, Your Lordship.
4 weeks.
4 weeks, Your Lordship. Your Lordship, similar prayer for item number 16 and 17. Here, Mr. B. Pata could not appear, Your Lordship, due to personal difficulties.
No objection.
There it's a prayer of adjournment.
It's a prayer of adjournment, Your Lordship.
Just on prayer made on behalf
16 and 17, Lordship.
on behalf of the learned counsel appearing for the petitioner. On behalf of Mr. B. Pata, learned counsel appearing for the petitioner. This is matter for 2 weeks. Yes.
Deeply obliged, Your Lordship.
16, 17.
May it please Your Lordship,
Yes.
I beg to mention item number 23.
Item
Item number 23.
23.
Your Lordship, may this matter be taken up after 2 weeks, Your Lordship. Mr. P. R. Paskia could not appear on account of bereavement in the family.
Yes.
No objection.
You are appearing for the respondent, item 23.
My lord. Pirvela Rani. I am there, my lord.
Yes, item 23. Yes, on prayer made on Mr. P. R. Pascal, learned counsel of the petitioner. List after 2 weeks. 2 weeks.
Deeply obliged.
Yes.
Please, Your Lordship, I beg to make a mention of item 20.
Item
20. Similar matter is pending before the division bench.
is connected with those. Okay. 20 also after 4 weeks. You just on prayer. Yes.
Deeply.
Item number 1.
Please, Lordship.
Yes, Mr.
So
Dev.
I filed a civil revision being aggrieved with the order by the trial court, whereby, Lordship, my application to an order was passed by which defense witnesses, I am the plaintiff in a suit, eviction suit.
You are pending in an eviction suit.
I'm sorry, I am the defendant in the eviction suit. I am the tenant. So against me, a suit was filed for eviction. In the course of the proceedings, I duly participated. Cross-examination of the PW's plaintiff's witnesses were done. Then I, as the defendant, as DW1, I was examining myself. In the meantime, what happened, Lordship, the original rent receipts, through which I wanted to show that I have been paying the rent, the originals were misplaced. So I filed an application to...
Misplaced means it was not filed with the, along with the...
No,
along with
Lordship, the originals were not in my possession. They were misplaced, Lordship. So I filed an application to allow me to produce the Xerox copies and exhibit them as paper marks.
secondary evidence.
Lordship, as a secondary evidence in the course of my evidence, my deposition. Lordship, in the meantime, what happened is, due to certain reasons, I could not come on a particular date for cross-examination, while my application was also pending consideration. Now, seeing my non-appearance, Lordship, the learned trial court dismissed the petition along with and closed my cross-examination. And also closed the...
Along with?
While dismissing my petition not to allow me to exhibit Xerox copies, they also closed my cross-examination.
That helps you. If you are not cross-examined, your examination chief will stand.
Lordship, yes. Now, no, I was partly examined. Cross-examined.
Whatever it is.
Yes.
The remaining part of the cross-examination
Yes. What has not been
is
confronted
closed.
yes.
In such a case, you are benefited, the plaintiff would be loser.
I appreciate, Lordship. Thereafter, what happened? I wanted to adduce few other DWs also to support my bona fide. That was also not allowed, and the matter proceeded ex parte against me.
Where is the order?
Now, against that, I filed an application to recall those orders, and that was dismissed, Lordship. So, against that, I have come. That Lordship will find the impugned order.
You file an application to allow you to adduce secondary evidence.
Lordship is.
And on the day of consideration of the that application was filed during the course when you were
During
examined.
my cross-examination.
And then on the day on which this application came up for consideration, you were absent.
I was absent.
Now your petition was dismissed
And my
and your
cross-examination
was also closed.
Closed.
Now you filed thereafter an application for recalling that order.
Recalling the order to allow the cross-examination and to allow me
Allow
to
the
adduce
cross-examination.
the
You want to be cross-examination, you have a...
Yes. I wanted to show those right here. Now that application was dismissed on the ground that I am not interested in the matter. So that is the
On the
situation.
ground is means you have again committed default.
No, what had happened, Lordship, is that what had happened is the concerned council, the records were lost in the fire. So he had filed an adjournment. There
You
was
have lost your rent deposit receipt. You have lost your file. You have lost everything.
in the fire, Lordship. So that is why the matter was, my application was pending for a good amount of 2 years' time. And then eventually, Lordship, I had on the day when it was supposed to be considered, I made a prayer before the trial court saying that I have just received the certified copies yesterday of that application. So I was praying for another date, but the learned trial court has dismissed it, Lordship.
When this suit was filed?
Lordship,
When this title suit was filed?
Lordship, I'll just give the dates, Lordship. Lordship, suit was filed in 2017, on 21st March 2017. I had filed my WS immediately in June 2017 itself, Lordship. And by the
There is a
time...
condemnation application here also.
Lordship, yes. I have filed it by way of abundant caution, although this is under 227.
Why 227?
227 read with 115 of CPC, Lordship.
How can both be invoked together?
Because there is an apparent error in the jurisdiction, Lordship.
So 227 what has to do with apparent error of jurisdiction?
It may be read as a 115 application, Lordship. I have put it as a 227 read with 115 revisional powers under.
Now this has become a ploy nowadays to invoke so many provisions of law that if you fail in one, then you.
No, it's not for the purpose of avoiding the delay. That's why I have put the.
This
delay
also has to be dealt with.
I understand.
If statute provides for something, you are not supposed to invoke constitutional remedy. Constitutional remedy would be invoked only in exceptional situations.
I'll keep it in mind, Lordship. I'll keep it in mind. It may be read as a
Anyway,
115.
we will just issue notice and condemnation. Just miss case 13. Heard Mr. SW Learned Counsel for the applicant. It is applicant or petitioner? Petitioner.
Applicant, I have filed a separate miscase, Lordship.
With the miss case only. This is, but then here also you have also written.
Petitioner responded. I'm sorry, Lordship.
Then your government says applicant.
It should, the cost title should have. I'm sorry, Lordship. I apologize. Delay of 84 days, Lordship.
There was a time when we used to practice.
Lordship.
The drafting is to be taken very seriously.
I completely.
Now it has gone because of the lenient approach. And it has given rise to the insincerity in lawyers.
I appreciate it. I have nothing to.
That has to be checked. It is your office work.
I.
Heard Mr. Sansel, Learned Counsel for the applicant. Issue notice. Returnable in 3 weeks. You take steps in miscase, huh?
Lordship.
Returnable in 3 weeks. The applicant shall take steps for service of notice upon the respondent within 2 days.
Lordship.
List after 3 weeks. Yes.
Much obliged.
Item number 2.
This is regarding the condition of delay, my lord, of some days delay, where the petition was dismissed on default during COVID-19, your lordship.
Yes.
So, that's the case. Your lordship, according to my calculation, your lordship, there is a judgment and order where I rely, that is on by the Supreme Court. This is the one. Page 4, para 3, lordship.
Yes.
According to this order, that number 3, in cases where limitation would have expired during period between 15/03/2022, 2020 till 28/02/2022. Now, my lord, as per this, your lordship, as per this judgment, your lordship, I have.
You read it, complete the reading. What happened?
Lordship. Notwithstanding the actual balance period of limitation remaining, all persons shall have the limitation period of 90 days. Days from 01/03/2022.
Yes.
In the event of the actual balance period of limitation, the remaining with effect from 01/03/2022 is greater than 90 days, that longer period shall apply.
So that means the simple meaning is that from 1/3/2022, you have another 90 days time.
90 days.
And your limitation will start to be counted only after the expiry of that 90 days, isn't it?
Lordship.
So it means 1/3, we go to 1/4, 1/5 and 1/6.
That limitation will start from
31st May. It means we can say roughly it will start from 1st of June.
possible.
Maybe 1-2 days here, there, if you take into consideration mistakes. Okay. Now, tell us what is your period here. Your case was dismissed on which date?
Dismissed on the 01/02/2000, no, 21, I think. Let me see this. Lordship, this time. Yes, it is dismissed on 01/02/2021.
01/02/2021. Yes. So your period exempted was up till which date? As per the judgment of the Supreme Court, which date? Till
Yes,
which
it
date?
It is till 28 February 2022. Till
And what about the 90 days then?
the period will till 28 February 2022.
Yes, Mr. Sangresho, you have seen, you know that thing. So that means he gets another 90 days from 28, isn't it? So his limitation will start only after expiry of this thing. So when it comes, now, if you calculate 90 days, then what this is? First?
My lord, the limitation clock will start running from 29 May 2022.
29, yes, okay. So he gets further thing. Of course, he is not aware. Of course, he is not aware, but then he is getting it. It's okay, okay. Thank you. We'll just come to you. Yes, just tell. Now, you just say, from 29th May 2022, how many days delay is there? This is an application seeking restoration, that dismissed for deferred. Yes.
Lordship.
You have not calculated, Mr.
Lordship, I would just.
Well, to simplify, I just assist. My lord, I have just calculated it. Just submit it.
Now, when did he file this instant application for restoration?
21 June 2024, my lord.
My lord, according to me, after excluding the Supreme Court order, copy to copy and submitting to court master. My lord, according to me, 809 days delays are there. Now, if we start from A,
809 days delay from with effect from?
yes, from 29 May 2022. Now, to clarify that point.
So his 90 days expires on 28th May.
Yes.
From 29th you start computing. And then he filed on which date?
My lord, he filed his petition
21 June. 21 6 2024, my lord.
Okay.
Yes, he filed on 21 June 2024.
21 June 2024.
Yes. My Lord, in serial number 1, therefore, just in correction, Lord should be back. Then January 2022 is the order passed by Supreme Court, which my friend has shown. We start from there. Now, Supreme Court excluded the period from 15 March 2022 till 28 February 2022 from the period of limitation plus 90 days.
Yes.
That is, 90 days would be with effect from 29 May.
Yes, that is what you have said. Yes, you have
Yes.
said.
Yes. Now, please kindly, okay. Now, number 2, 29 May 2022 to 21/6/2024 is the date of filing this application.
Yes.
Hence, the clock of limitation for filing the instant restoration application starts running from 29 May 2022 and ended on 21st
The date of present
June 2024. That is the date of the recent restoration application was filed after availing the benefits of 424 days grace or exemption period with effect from such and such. That is the date of dismissal of the writ petition till 29 May 2022. That is
So,
the ending of the grace period.
So according to there are 809 days of delays.
Yes.
That is with effect from 29/5. So what that is where we need require explanation
Yes, here it needs explanation. And there is no explanation in that case.
for these 809 days.
Yes.
Now his petition speaks about delay of how many days?
500, my lord, his application. My colleague says 518 days.
No, 491 days.
Yes. So whatever may be 590 days or 800, my submission is that there is no explanation. But I'm not technical plea that day-to-day explanation is not required. But there is no reasonable explanation within this application. He have promptly filed after enjoying the Supreme Court exemption. But he didn't file 2 years ago. And after 2 years also, there is no explanation. So his application is not made any suffer from not explaining.
If there is no explanation, then we have no other option but to dismiss it. There is no explanation for
There is no
809
proper
days.
explanation in his.
Now let us see what he says in his explanation. Yes, Mr. Sangma, where is your explanation? Now, do you agree that you have to explain for 809
Yes,
days?
I have explained, my lord.
No, the calculation given by the senior counsel here is it all right? Do you agree with that?
No, I'm not agree, lordship.
What- according to you, what should
calculation,
be?
okay, but then there,
Then
of
tell
course,
us,
I
please.
admit there is some calculation.
Just a minute, just tell us what, according to you, what will be your calculation? Please give us.
That calculation is right, but
How
I
many-
have explained.
That is what the court is asking you. The senior counsel has given us only the calculation, nothing. He has not offered any explanation. It is for you. Do you agree that there is a delay of 809 days?
No, according to my calculation, this 491 days delay.
So just show
that is
us.
all.
Please give us the basis of your calculation.
Is that
At least you are agreeing that your limitation will start running from 29/5/2022.
lordship,
Do you agree?
lordship.
Or if you go by your thing, then you have to extend 90 days more time also. I do not know whether you are getting it or not.
But that delay, whatever may be, that delay, the reason I have explained, lordship.
We need explanation for that period. We do not need any explanation for any other period. We need explanation for you. Are you agreeing that there is a delay of 809 days? No.
The 890 days, but minus some
809
was-
days, not 90 days.
Yes.
So you
There-
do not know how many days delay also is there.
There, yes, lordship, but there was a delay. But then so I have minus some days which has exempted.
Yes, you have minus which way?
Then
Show
accru-
us. According
yes,
to you, what is the delay? Just tell us.
yes, according to my
Just tell us, give us the
calculation,
period. It's very difficult to interact with you, Mr. Sangma. Seems
491
you do not know your
days.
case also.
491
Oh,
days.
from which date to from which date? Just say.
That is date 15 March 2022 till
15th March.
15 March 15/3/2020 till 28/02/2022. There is a
Forget about that exempted period which Supreme Court says. Just forget it. Forget about the period
yes. Then
till that.
That one I have minus with the Dr. delay.
You tell us what is your total delay, then there's the question of minus will come. Tell us what is your total delay, then we'll minus.
Dr. delay is
see till 29/5/2022. If you agree on that, then you do not have to offer any explanation. When was your suit dismissed? It was dismissed on
1/2/2022. 21.
Yes. So at least till 29/5/2022, you do not have to give any offer any explanation. Now you say that your delay is how many days?
491 days.
From which date? With effect from?
It will effect from 28 February 2022.
Oh, then this 92 more days more will be added to your calculation. Then it will become 899 days. So you are giving a lesser calculation than he. So see now 899 days then. Probably you have not understood even the order of the Supreme Court also. Anyway, we take it. So according to you, limitation will start running
from 28 February 2022.
Yes. Now from 28/2022 till
31st June 2024.
How many days it comes?
Is 1,206.
So according to you, there is a delay of 1,206.
Yes. Then 1,206.
1206.
Yes. Yes, Lordship.
Yes.
Then, Lordship, according to my calculation, from there I have minus the exemption date, which is equal to 715 days. 715 days, according to my calculation. Then from Dr.
No, exemption date.
From that there is a day from 15 March to 2020 till 28.
No, this wait. Do not just go on reading. The court has to understand. Now you say 700 and some days has to be deducted from that period.
Lordship.
On what basis? Why?
From there is from the Supreme Court order where it says from the exemption date from 15 March 2020 till 28 February 2022.
Oh, that you have said. You have calculated your limitation period from that only, from that date only. That is what you have said just now to compute 1206 days.
Yes.
Perhaps you are not clear of your case. 28/2022 you have already taken into consideration. According to you,
yes,
we have exempted that period up till 28/2022.
From that,
though senior counsel's calculation helps you more, it gives you another 90 days rebate, but then you are not going by that. According to him, it is 809 days, and according to you, it is 1,206 days. So give us explanation 1,206 days, and what for the 700 or some days we should reduce? From which date to which date?
That is which the date from 15 March 2022 to 28 February 2022. The
from
day is
15/3/2022 to
15/3/2022 2020 till 28
See, again, this is a problem, Mr. Sangreso. Perhaps he doesn't understand what he is saying. He himself is saying that till 2022 it is exempted. Now he is calculating again 2020.
You cannot comment.
Now this is the problem.
For his satisfaction, let him, my friend.
Which way,
calculate.
just tell us which way a court can help it.
No.
See that situation.
For
Just
his-
tell us.
Perhaps my colleague is here to appreciate my. Let him calculate and give a
You see,
piece-
you
piece
have
of
to
paper
have
tomorrow.
help
Yeah,
from
tomorrow.
somebody if you do not understand that.
For his satisfaction.
You are not helping the court. Those are creating a total
Lordship,
confusion.
I'll prepare the chart.
For his satisfaction, let him calculate. Place on record on my Thursday or Friday, whichever. Finally, madam.
What request, Mr. Sangresho? You have given a chart. So far as the Supreme Court order is concerned, that is an admitted fact, isn't it? None of us. You see, forget about this part. Even court also cannot defy that. We have to. That is binding on us, isn't it? So where is the question of, you see, like making any calculation by overlooking the period exempted by the appeals court? What is the question?
Or should we pass necessary order?
And that too also is going against his own interest. He himself is extending his period of need. Probably another, before also 1 2 days we have heard it, and then
Yeah.
we ended up with the same kind of confusion.
Lordship, may I pray, Your Lordship, there may be mistake in my calculation. However,
See, it is not that your petition, even now also you do not know what submission you are making. That is what appears to the court. You yourself is not, you are not clear. You yourself is not clear what is the period of delay. You yourself is not clear what period should be condoned. Which period should be explained. You do not know. It appears to the court.
Your Lordship, the delay, whatever actually I've mentioned in the petition, of course, that is, there's a defect in my calculation. However, for whatever the delay, Lordship, I have explained that that explanation I have given, Lordship.
How do we take whatever the delay? You see, it is not a court of equity, you see. Court cannot show any kind of mercy. If court has to show anything by travelling beyond law,
No,
that will be injustice to the other side.
Lordship.
You have to do justice to both the party, not to you, isn't it?
No, my submission is, of course, there is a defective in my calculation, and then it's not matching with the Supreme Court order. However, of course, there is a technicalities. I admit there is a lot of mistake in my calculation because that is true. My only humble submission is that some this cost may be imposed, then my delay may be condoned because there is only 400.
Show us any law that we can do it.
There is no law, Your Lordship. Of course, however,
court will not do
I'm not
anything.
saying, Lordship, I'm admitting, Lordship. Technically there is some mistake calculation here and there. That is I admit.
See, Mr.
I'm
Sama,
saying, but Lordship, I have explained.
where is
for
the
whatever-
explanation? Show us explain. If you
Yes,
say
the
explain,
reason,
you just show us the delay from period. See, we do not want any explanation for the period which law doesn't require. That it should be explained.
That's why I'm
You
saying.
explain
Lordship.
only the period which is required by law to be explained. The problem is that you are standing up without understanding your case. You have stood up to argue a case without knowing your case. That is what the problem is. And you want the court to overlook everything and to show mercy to you and accept whatever reason is stated in the petition. So that justice is done to you, but then at the cost of injustice to other side.
No, Your Lordship.
That is what your submission
that's
is.
Not my intention. My submission is I am admitting there is a mistake in the calculation.
So you correct it. You give us proper explanation for the period which is required by law to be explained. Do not consider no other place, 2020 and all, already exempted by Supreme Court. Why you are again going back there? This court is not asking you. You do not understand even the submission of the other side also. The calculation given by the senior counsel helps you. It's 90 days lesser than what you have calculated, or what maybe a correct calculation is.
Lordship, that I'm accepting the calculation because I'm just replying because according to my calculation, that was the date. Now I'm not denying
You
I'm
give
not
us a
denying-
chart of your calculation
Lordship,
right now, we'll decide
Lordship,
the matter right now.
I'm not denying the calculation given by the senior counsel. I'm only stating that according to my calculation, there is a difference. Does not mean that I'm denying or refusing or not agreeing to
But then you are
his calculation.
maintaining your calculation.
No.
That amounts to denying.
Lordship, I'm not maintaining, but just since court has a query saying that according to my calculation, I'm saying that of course there is a defect in the mistake in my calculation. Since court has asked me
Now you
my
understand.
calculation,
You understand how defect is there.
I admit.
You understand?
There is
Do you
a
understand
defect.
how your petition has a defect?
Yes,
Please
Lordship.
correct it and give us tell. Say what is corrected version. Give us.
Yes, I'm saying
Now
that.
you know the defect. Please tell us how it is to be corrected.
No, in that case,
Tell us. Then we will not adjourn it. We will decide it right now.
That
Tell us.
senior advocate, what he has given, that I accept that calculation, Lordship. But only thing is that, of course, there is a defect in my mistake. Does not mean that I am not asking the court to go by my petition. I'm saying that there's a defect since court has asked according to your calculation. That's why I have given my explanation, though it is wrong. So I'm not asking the court to agree to my petition, whatever it is written. I'm agreeing to I'm saying that there is a defect in my mistake. There is a mistake. And then I said, according to my calculation, that is a thing. Does not mean that I'm asking from the court to consider whatever maybe it is in the petition. The learned counsel has given the explanation. I'm agreeing to that. But since court has asked me, since there is a defect, I said, according to that is the only thing. But I'm not insisting that I'm never saying that there is no defect in my petition, or I'm not insisting to agree to my petition. That's why my only submission is, since, of course, I admit there is a technicalities in difficulties, personally difficulties in calculating the days and making as per the according to the judgment. Therefore, I am not saying that of course there is a delay and there is a mistake in my petition, and then I am admitting whatever my learned friend has given, the senior has that is the correct calculation. However, whatever may be the reason, of course, I have explained the delay, but that explanation to my delay, since the calculation itself is wrong, so that will not be acceptable. Therefore, I am saying that there is a technicality. I am admitting there is a wrong, and then there is a defective. However, I am saying that therefore, due to the technicalities and due to defect in my petition and calculation, the litigant should not suffer. Therefore, I am saying that at least these technicalities may be considered by imposing some exemplary course, and then the case can be gone merit. That is my only
That can be
submission.
done in law. Can it be done in law? Whatever you say, can it be done in law? While considering the period of delay.
Of course, that cannot be done. But then,
It cannot be done, then do not make this prayer in the court.
but the thing is, since actually,
Kindly see, as a lawyer, if you know something cannot be done in law, then you are not supposed to make this prayer.
no, I'm saying only, Lordship, I'm only saying there is a defect in the petition, there is a mistake in the calculation, since I have miscalculated. So, that miscalculation.
We record your admission and we will reject your thing. We will say that you have miscalculated, and because of the miscalculation, your explanation was not given properly, and that explanation we cannot use. We will say that you have frankly accepted. That is what we will do.
Lordship, in that case, Lordship, I will prepare another charge sheet. Then
You can prepare any charge sheet you want. What we want, that a logical explanation from you. Nothing else. Court is asking for that, and you want the court to overlook everything. You want to say that court should overlook even the period which should be taken into consideration for calculating the day of delay. Your thing is that since I have given some reason in the petition, please accept it and do not look at the calculation, because I have committed a mistake. That is the sum and substance of your argument.
actually, petition, of course, since I'm saying there is a miscalculation, whatever the miscalculation, however, there is explanation actually I have provided. That's only my submission.
See, your explanation, since it is not on the basis of the calculation, so this explanation has no value. Because you have explained the period where law requires no explanation. and you are not ready to accept it.
Your
And
Lordship.
in your submission, again you are saying that period from 15/3/2020 you have explained. What you have to do with 15/3/2020?
Lordship, then in that case, I will prepare one more chart. Then they will give explain to the same in that chart. Give me some time. Prepare according to
There
that.
is no problem in giving time. The problem is that you understand the matter in its proper perspective. That is what the problem is.
His Lordship, that is correct, Lordship. But
So
only
that is what the problem is. See,
only thing is I find it difficult to only take
if you have
conclusion.
enforceable right before this court, similar to the situation on the other side. So what we try to determine here is that who is legally correct, and we pass order, not by showing mercy, by traveling beyond law. Just say right on prayer made by. Well, Mr. Sangresh, we are just giving some more time. Whether you prepare a chart or you do not prepare a chart, it's up to you. But then make sure the next date we will not. If you can explain, it's okay. We will not do this. And the biggest problem is that even in the courtroom also, during the course of hearing, the clues, whatever you get, that also you don't understand. Just say, on prayer made by, this will be the miss case, huh? Miss case 1 debate. On prayer made by Mr. P.T. Sangha, Parliament Council. On behalf of the petition. This is matter after 2 weeks to enable him to prepare the matter. Yes.
Much less, Lordship.
Item number 3.
May it please your Lordship.
Yes.
Lordship, I had already taken steps upon the respondent. Tracking report suggests that it has already been delivered.
It's a return answered. What for it is return answered?
The first time also I had taken steps, it returned, my lord.
Have you checked?
No, my
The office note indicates that it is the notice upon the respondent number. The sole respondent has a return answer. So addressee, it seems addressee was not available. So what is to be done? You will take fresh steps? Or?
I've already taken 2 times, my lord. I can
You
take
already
again.
taken?
I've taken 2 times, man. This was the second time I had taken steps.
So what is to be done? You will make then publication. What shall we do?
Instructions,
Or
my lord.
can you do Dusty?
I'll try, my lord. I can try to Dusty service.
You can try, means like you have to say that if you make a submission, we will record it, we will pass order. You have to be sure before you do.
I'll take steps through Dusty service.
Is it that this respondent is trying to avoid service of the court?
I'm not sure, my lord.
You are not sure. Then you must have some information.
My instructions are that if they entered appearance, we were ready to go for mediation. If they entered appearance, my lord.
See, they have not entered appearance. That is the thing. Our prime concern is how to make them appear before the school.
Yes, ma'am.
Because until and unless service is affected or it is shown to have been refused, we cannot record that it was duly served.
Yes, ma'am.
So, which way it is to be done, just see. And what law says.
I can try through Dusty service, madam. I may be allowed to take steps through Dusty service. There's an interim order as well, my lord, that may kindly be extended.
Interim order passed in this case? Or
Yes, ma'am. Interim order dated 26/6.
Is it in this case or what? Or in this case?
Not in the main case, ma'am.
In the main case?
Yes, ma'am.
Okay. Just say the office note indicates that the notice upon the sole respondent has returned answer. Aspect for by the learned counsel for the petitioner. Aspirate for, comma, the petitioner is allowed to serve the respondent by dusty service. Stop. This is met after 2 weeks. Then you say interim order passed earlier. The interim order, if any, passed earlier, shall continue till the next year.
Much.
If you file a dusty service, then you have to file a report also of dusty service.
Yes, ma'am. Yes. Much obliged.
Item number 4.
May I please, Your Lordship? Your Lordship, we need some time for instructions, Your Lordship.
Your respond number 1 and
1 and 2, Your Lordship.
so you are entering your appearance today, or you have already entered?
Your Lordship, we have already entered our appearance.
How many respondents are there?
1
2,
and
Your
2.
Lordship.
1 and 2, Your Lordship.
1 and 2.
On the last occasion, Mr. Deb appeared.
No, Your Lordship. Me only I have appeared.
Mr. S. Deb. That is what this order sheet says. Have you filed your power?
Yes, Your Lordship.
No, halat no filed here.
My lords, in this case, senior conducting counsel, who's standing counsel for cantonment, will be appearing, Your Lordship.
Respondent number 1 and 2.
For respondent number 2, for respondents, Your Lordship, 1 and 2.
So who is Mr. S. Dev who appeared on the last occasion? This is the order sheet says.
Yes, Your Lordship.
We'll record your thing, Mr. Lindo.
Yes, Your Lordship.
This only cantonment board.
Cantonment board, Your Lordship.
So have you received the copy of the petition?
We have received, Your Lordship.
You are there together, both of you
Yes,
are.
we are from the same chamber, Your Lordship.
So you can record either. You can record who's then. So Mr. Mohanto will represent here.
Yes, Your
Shall
Lordship.
we record it?
Yes, Your Lordship, we can record.
Mr. M. Lindo, Learned Counsel, applying for the respond number 1 and 2, submits that. No, just say Mr. Lindo, Learned Counsel, submits that respond number 1 and 2 will be represented by him. Will be represented by him in the case. Along with Mr. S.P. Mohanto, not a senior counsel. No, say senior counsel cannot represent. He just say submits that Mr. S.P. Mohanto. Or can you accept behalf of this thing, Mr. Mohanto's name? Are you a panel lawyer?
No, I'm not a panel lawyer, Your Lordship.
So then, which way then we can say pass this order? Shall we say that you will be led by Mr. Mohanto?
Yes, Your Lordship. I am led by conducting senior counsel S.P. Mohanto.
Because there is some difficulty in the sense that we cannot say that senior counsel will have.
Yes, Your Lordship.
Notice. Just cancel that line. You just say Mr. Lindo, Learned Counsel, submits that he will be led by Mr. S.P. Mohanto. Learned Counsel appearing for the respond number 1 and 2 submits that he will be led by Mr. S.P. Mohanto in this matter. Stop. The Learned Counsel prays for grant of some time to take necessary instruction. Prayer allowed. List after 2 weeks.
2 weeks. Oblige, Your Lordship.
5.
Please, Your Lordship. Your Lordship, I've received instructions in this matter. I'm praying for 2 weeks' time to file an affidavit.
The state is the only party. There is no
Yes, Your
private
Lordship.
testimony.
My lord, if I may submit, my lord. About a month back, my lord, instructions were received. That was the submission made, my lord. So, I don't have any objection to the, my lord, time.
This is a new
But my
case.
miscase may be heard, my lord.
What is that miscase about?
My lord, I'm praying for staying the DP, my lord, departmental proceeding.
Your Lordship, I'll file my affidavit within 2 weeks, Your Lordship.
There is a miscase also.
My lord, it may be heard the next date, my lord.
See, until now, unless already response is there in the record, any order passed in the miscase.
No, my lord.
File affidavit, we will decide
Yes,
it
Your
on
Lordship.
this
I'll
thing.
file it within 2 weeks, Your Lordship.
And this is not a thing, you are there, out of service for quite some time. So it is not a new case.
Yes, Your Lordship.
Then what kind of interim order you expect at this stage?
My lord, if I may submit, my lord.
Anyhow, just we'll just see. Let us see. Let the state this thing.
My lord.
Okay. As prayed for by MS JD Namprindi, GA. Appearing for the state respondent. 2 weeks time is granted for filing affidavit opposition in the matter.
Obliged, Your Lordship.
Deploy.
7.
My lord, I will pray for some more time in this matter.
Yes.
I will pray for some more time, my lord, in this matter.
Okay. You'll file an affidavit in this matter?
No, my lord, I am not in a position to get even the instruction.
No, whether you will be filing an affidavit or...
I will be filing a short affidavit, my lord. But I am
So-
praying for affidavit, my lord.
We'll just give you time for filing affidavit.
My lord. 3 weeks may be given to me.
Yes. So, yes, for by Mr. SD. 3 weeks time is granted for filing affidavit in opposition. Mr. Day appearing for... You are appearing for all the respondents?
All the respondents.
Okay, Learned Counsel appearing for The respondent's 3 weeks time is granted for filing affidavit in opposition.
Hello.
Hearing item number 8.
Item 10 and 11.
Yes.
These are analogous matters, my lord.
Yes.
That was already heard. My lord, on the last occasion, time was sought for filing of the written argument, my lord. As far as our written argument
There is there is nothing in the last order
of course, it is
about
not
the written
reflected,
argument.
my lord. Because prayer was made on behalf of private respondents.
Yes.
Of course, that is not reflected in the order, my lord. So, nevertheless, our written argument is ready, my lord. I'll file it. I can file it now, in fact, my lord. Another 10 minutes.
Was there any order, Mr. Sangreshu, to file written
In that
argument?
regard, order is not reflected, but on his prayer, Lordship has given time. And they are supposed to submit today.
Written argument?
Yes. Mine is ready.
And what about your argument, Mr. Sangreshu?
I've submitted already.
They
have filed.
Already have filed written argument. And that written argument will suffice your thing.
My lord, that will cover my entire argument. Only the private respondent, my colleague, Mr. Nadis.
Yes.
Your Lordship, already I filed the synopsis of this argument. So, Your Lordship, after having the state's argument, if I having anything to say, then only. If the state arguments I got, and then after this I can just, if anything is still required. Otherwise, synopsis, whatever I given, Your Lordship, it is covered all.
Mr. Sangreshu, you have filed it on 6th June?
My lord, I have filed already with a copy to my learned two friends. I'm going to receive from my friend. This is mine. We have not received a copy. Nevertheless, my lord, I am filing it today.
You without receiving copy, you will file it. Okay?
My lord, my copies.
Huh?
Because this copy was never made over.
That is okay, but then if you are satisfied with the receiving copy, you will respond to this thing.
The only thing is that, my lord,
it's up to you.
This subs by bullet point only. Already argued and that's copy.
Yes.
That is the bullet point. That is the main thing only.
Exactly.
I think that will cover. We do not know. This court doesn't remember anything of the argument because when it was made and all that also the court doesn't remember. But then if you say that your bullet point will take care of that, that is all right. That is all right.
Let my friend submit his today.
Yes.
Let it
And
be released.
then we'll see for this thing, Mr. Devnath. He may have to respond to this state thing also. Okay, just say.
Only thing, my lord, because since I have not received a copy, I'll submit a copy straight to the court, my lord. I'll not be giving a copy.
That is the normally submission of the gist
What do
of
you
the
mean
point.
by that, Mr.?
Hello,
That since they have not supplied you a copy, you will also not supply the copy. It's like a tit for tat or something like that. Is it something like that? Is this the way court procedure goes?
No, my lord, that is there. So, my lord, they were...
No, but then that was irresponsible. That is irresponsible on your part that you file your response without even looking at their list.
No, I have not even filed, my lord.
Then?
Not yet filed.
Then?
I said I'm ready.
Then?
So, my friend may give a hand...
At least this court has not come across any defense lawyer or any state counsel who without looking at the argument made on behalf of the petitioner, would submit his...
Let them hand over a copy to me.
If I recollect properly, my lord, once the oral argument is completed, then party is allowed to submit the gist of the point.
That is,
it is
you
not
see,
required to
if
refer
you
each other.
choose to do it, and sometimes if these facts are very lengthy and voluminous, that helps. If you give written juice, that helps the help the court. Now, is there any order by which we concluded the oral argument in this?
In fact, those previous order are there, if our memories are correct. Quite some time after that, my little friend sought number of time.
It was long back.
That is the problem, Mr. Devnath.
After that, status filed the affidavit. So
No,
this
this is March after filing.
6 June 2025.
6 June 2025, you have filed your written notes.
Yes. And my little two friends sought for time again.
What is the subject matter involved here, Mr. Sangresha?
Appointment, the termination of the assistant teacher in ad hoc school.
By the
SSA school, by the managing committee.
Aided school?
Aided school. It's SSA school.
It is the SSA service.
SSA
Under
school.
the SSA, my lord, service Shiksha.
Okay. Just say, Mr. K.P. Bhattacharya, Learned G, appearing for the restaurant number 1 and 4 submits. You will submit it today, or you would see their argument first and
Let them give a hand over a copy, my lord.
okay, Mr. J submits that.
The term is, my lord, he will go through mine and he will counter it. Not only gist of the matter is not required. Once the both party has advanced argument,
No,
the lordship
nevertheless,
give
my lord, let
time,
them hand over.
give time to both the parties to give a submit gist of the thing.
And we'll just Mr. submits that the written gist of argument submitted on behalf of the petitioner. The copy of the written gist of argument submitted on behalf of the petitioner has not been supplied to him. The petitioner shall supply a copy of the same. Is there any difficulty of this thing?
Normally what the government is doing, my lord, after we submit, they will look into our pleading and give a counter. In fact, that is not the correct procedure.
that is exactly
Once a
how it
party
is.
advance argument completed, lordship give us to submit the gist is to enable my lordship to pass the order. What the respondent do, my lord, they want to obtain ours, go through again and give a counter and submit where I won't have any chance to reply.
It's a
So
natural.
that is only a gist.
It is of the point only.
Anyway, and you supply him a copy of this.
I can give
Okay.
no harm.
Submit, what you said?
What is going on?
The petitioner shall supply of the copy of the written. What is it? What the first one? What was that? Supplied to him. Stop. He, however, submits that written gist of argument on behalf of the state respondent would be filed during the course of the day. Mr. Devnat, learned counsel appearing for the respondent number 527. Submits that he would conclude his argument after receiving the copy of the written gist of argument of the state respondent. You have received copy of Mr. Sangresho.
This already.
Mr. Sangresho's one you have received.
I need it.
You have received.
I have received.
Say it clearly. You just say reply. Yes.
10 days is given, so I am not going to. Already state is given, so if it is given, it is given.
No. Whether you do not want. Okay, you do not want a copy of this.
No
Okay,
need.
no. Okay. In view of the submission made by the parties, this is matter. After 1 week, will be all right. This matter, if any clarification is needed. Huh? But then if this, you just accommodate after next week these things, because they say that argument is complete. Okay, it is a submission with the parties. This is matter after 1 week. Stop. In the meanwhile, parties shall exchange the copies of the written gist of argument submitted by you. Okay, so that there remains no grievance at least.
13.
Well, 13, I'm praying for some time, my lord. Even if you have to start now, my lord, will not be able to.
No objection, Your Lordship.
1, 2 weeks.
Well, after 2 weeks, my lord.
One prayer made by Mr. K.C. Gautam, Lord Counsel appearing for the petitioner, not objected to by MS Ilingua, London GA. This is matter after 2 weeks.
Much obliged, Lordship.
14.
Well, 14 is that part out matter, my lord. It's not
Part-heard matter.